Share your thoughts and ideas by liking and commenting on the video below. And don't forget to tap the subscribe button. Click on the notification bell so you don't miss any of our contents. The court must make the autopsy reports public, in Christopher Watts' case, Tribune said. Last week, the Tribune, in conjunction with media partners across Colorado, filed a motion in Weld District Court seeking to make public the autopsy reports in the murder trial of Christopher Watts. Autopsy reports long have been considered public documents. In fact, it took an unusual motion from the Weld District Attorney's Office to keep the report secret in this case. There are good reasons autopsy reports, like other public documents, are public, and courts consistently have agreed. In the motion filed last Thursday, Steve Zansberg, a First Amendment attorney with Ballard Spahr LLP in Denver, who represents the Tribune and its media partners, argued the Weld County Coroner's Office, not the District Attorney's Office, is the official custodian of the autopsy reports, because they were made, maintained or kept by that office. According to Zansberg, any attempt to seal the autopsy reports from the public must therefore be initiated by Weld County Coroner Carl Blush in a new legal action that is separate from Watts' ongoing criminal proceeding. These aren't criminal justice records, they're public records. And if the coroner wants them sealed, he needs to abide by the statute and file a separate petition, Zansberg said. If Blush were to file that motion, he would have to prove releasing the autopsy reports would result in extraordinary injury to the public interest. In his 22 years representing Tribune and other media outlets, Zansberg can remember only one instance, the Columbine High School massacre, in which a judge ruled the release of autopsy reports would adversely affect the public, he said. We fundamentally believe in a democratic society, that the records detailing actions undertaken by officials who serve that society must be public. In the absence of such transparency, we cease to live in an open society. That's no less true of autopsy reports than of other public documents. The functions of the coroner's office represent some of the most meaningful, decisive, and important ways in which the state interacts with its citizens. The records of these interactions, undertaken on behalf of the public and funded by taxpayers, must be available for public inspection. Recently in Colorado, reporters have used publicly available autopsy reports to reveal problems in the state's child welfare system that led to deaths of children. In other instances, publicly reviewable autopsy reports have exposed public health challenges, raised questions about prosecutions in some legal cases, and helped journalists and others address a host of serious issues across the country. Specifically, the autopsy report sought by the Tribune and other Colorado media in the Watts trial likely will shed meaningful light on a high-profile and important case in which both the prosecution and defense are acting on behalf of the public and are funded with taxpayer money. Government is best when it's transparent. As a state, we have consistently passed, and courts have consistently upheld, open records laws, because transparency is one of our most enduring and important values. That's especially true when the information contained in public records is sensitive and complex, as is the case with autopsy reports. We look forward to seeing the court do the right thing and preserve the right of the public to scrutinize their records, the Tribune editorial board said. Thanks for watching. Check the description below to watch other videos dedicated to this case, and don't forget to tap the subscribe button below.